Thank you all for coming today. We're very fortunate to have Assistant Attorney General John Carlin, who is a 1999 graduate of this law school. He's a Hayman Fellow. He is the Assistant Attorney General in charge of the National Security Division. He's the top national security lawyer in the government. There are 400 people under you, roughly 400 or so people he supervises. And he was, before that, he's a career prosecutor. He worked in the FBI closely with Director Mueller as his chief of staff and senior counsel. He knows a lot about national security. He's going to talk to us today about cyber. Is that right? And then he and I are going to have a chat, and we'll open it up for your questions. Okay? Thank you so much, John, for coming.
No, thank you. Before I get started today, I did, in light of yesterday's events, wanted to extend my thoughts and hopefully all of our thoughts and prayers for those who lost their life and for their family members and for those who are wounded and recovering. And to those in state and federal law enforcement who worked bravely yesterday to apprehend those responsible and continue to work. So with that, I wanted to thank you, Jack, for the introduction, to Dean Minow and Jalissa Milligan for putting this together into the National Security Journal. I was a graduate of Harvard Law School in 1999, and I thought as we talked a little bit today to talk a little bit about the role of Harvard Law students in federal government. And when I graduated here, it was not necessarily encouraged to go into public service under the dean then. And it was thanks to folks who are here today, like Alexa Shabakov and Lisa Dealey and Professor Hyman, that they introduced me to those who are in the field of public service in government, and also made me believe that the reasons why I went to law school, that I could actually practice them, and I could go into public service and be in the arena, focusing on some of the most challenging issues now for lawyers, as you are faced with in national security in particular, where we're balancing constantly and trying to figure out how to preserve the fundamental values that we hold dear in terms of the protection of our civil rights and civil liberties, and at the same time to keep people safe in a world of increasing and complicated threat. So to those of you who are considering it, I want to encourage you that if that's the reason why you went to law school, that you can be directly engaged in the fight and that you're needed. Your skills are needed, your judgment is needed, your creativity is needed, and nowhere more so than in the issues of cybersecurity. It's a growing threat and an area that also provides tremendous opportunity, and there's almost no settled law, whether you're talking international law or domestic law. Everything is still developing as the technology itself developed. And Harvard Law School is playing a critical role in that debate now, thanks to the Berkman Center, to scholarship from individuals like Jack Goldsmith, Phil Hyman, and others. We're at a critical moment. I think the former director of the CIA and Secretary of Defense, Leon Panetta, described it in some respects as being a pre-9/11 moment when it comes to cybersecurity. And similarly, those who commissioned the 9/11 report on its anniversary in 2011 said in many respects we're in a pre-9/11 moment when it comes to cybersecurity, which is, we know that nation states and terrorists day in, day out are probing critical infrastructure, that they're planning destructive attacks, that they have the intention, particularly terrorist groups, to conduct destructive attacks, and in terms of what we're already seeing day in and day out, enormous theft of information, including intellectual property. Bottom line is we need to work to change the calculus for hackers. We need to apply some of the tools we've applied throughout law enforcement into other problems. That is, to be able to detect and deter those who would either do us harm or steal from American companies or individuals. There can't be a regime of free passes in this area. Let me start a little bit by talking about the National Security Division. We're a relatively new division at the Department of Justice. When I was at law school here, there really wasn't a national security law practice. I remember telling you, Phil Hyman's classes were one of the only ones that touched on it. It's amazing how much interest there is now in national security law. And similarly, at the Department of Justice, there was no national security division. The division was created after September 11th. It was the first new litigating division of the Department of Justice in about 50 years. It was created in 2006. And the idea was simple. It was to fix a problem that had existed prior to September 11th. Part of that problem was legal, the so-called wall between law enforcement on the one hand and intelligence community on the other hand, that each was collecting information, but they weren't sharing it across the divide. And part of that was legal, but part of it was cultural. Prior to the creation of the National Security Division, those lawyers prosecuting terrorist cases reported through one chain. Those doing espionage cases reported through a second chain. The lawyers who worked on intelligence issues reported through yet a third chain. Those are the lawyers who, in part, appear before the Foreign Intelligence Surveillance Court. And then there was a fourth chain of those lawyers working on certain national security regulatory issues, like the Committee on Foreign Investment inside the United States, or certain transactions before the FCC that might pose telecom risks to foreign adversaries. So the idea with the National Security Division is that does not make sense as a structure. That we should have all of the lawyers working on these issues in one place, under one Assistant Attorney General who day in, day out is focused on the protection of the country writ large from national security threats. And underlying this was a simple premise, which is instead of focusing on success as a successful prosecution of a terrorist after the terrorist attack has occurred, that instead we should be intelligence-led and threat-driven. And by that I mean having access to the full range of intelligence across the law enforcement and intelligence community divide, to look at what that picture shows us, and then to see what the threat is, and then to look across the full range of legally available tools to see how we can disrupt that threat, and not to be wedded to any one approach, whether it's criminal justice, whether it's the use of an executive order that allows the Treasury Department to sanction certain individuals or groups to prevent them from doing business with the United States, whether it's the use of a commerce authority to designate an entity as one that can't do business with the U.S., or whether it's the use of military force or diplomatic regime. We should be open-minded and, as lawyers, creative in terms of looking across the full legal playbook. And we've gotten good at applying this approach when it comes to terrorist groups. So to make it concrete, you'll get the intelligence. There's a particular designated terrorist group overseas. Here's the threat that they pose. Here are the actors. What's everything we can do as a government lawfully to prevent those terrorists from accomplishing their aim of causing loss of life? And that might be a criminal prosecution in the United States. It might be helping a foreign partner regime put laws on the books in their country that allows them to prosecute individuals. It might be a sanction, and invariably it's a campaign against that group that uses all those available tools. When I was over at FBI as Chief of Staff to Director Mueller, when he was director of the FBI was going through a transformation and getting better when it came to cyber threats and looking across that law enforcement intelligence divide, accumulating the information, and seeing what the picture showed. And they got pretty good at it. In fact, we had a giant Jumbotron screen. You could look at the screen, and in real time, you could watch the adversary, nation-state adversaries, jump in, intrude into systems like university systems here, then jump into U.S. companies. And day in, day out, we would watch the data exfiltrate out. And so while it was a success that we got better at watching it, what we were seeing was horrifying, right? So it became clear that this is not a traditional intelligence problem where they're getting strategic intelligence. They're causing actual harm now, because what we're watching is causing the loss of what our innovators develop. It's the crucial aspect of what makes the American economy successful, which is all the investment that's going into research, development, and innovation, and we're watching it get exfiltrated out. So we need to do something to deter it and disrupt it. When I came back across the street, and the FBI headquarters is right across the street from the main justice building, although I don't know whether it's apocryphal or not, but apparently Hoover made it one story higher so that he could look down at the Attorney General, so the director's office is a little higher. But it's right across the street. I came back across the street and I realized when I came back to the National Security Division that we were not applying some of the same lessons that we had learned and applied when it came to the terrorist threat. What do I mean by that? When I was a prosecutor prosecuting these cases and doing computer hacking cases, I worked on the criminal side of the house. I worked with an FBI squad, and we worked only on criminal cases. And there was a literal locked door, and on the other side of the locked door in the secure space was the intelligence squad. The whole time I was working those criminal cases, I never went on the other side of that door. And it's not like I was banging to get in on the door, because there's plenty to do on the criminal side of the house. But the fact was we weren't sharing that intel information with law enforcement to see what we could do. And when I came back to National Security Division, I realized, well, they're not doing it here, which means nobody's doing it. So one thing we started to do is try to apply the lessons on terrorism and start with, we need to have trained prosecutors in every U.S. attorney's office across the country who, just like they do on terrorism threats, are trained when it comes to cyber on the bits and bytes, but also on the Electronic Communications Privacy Act, the Computer Fraud and Abuse Act, and those statutes that are specific when you're dealing with cyber crime. And at the same time, we need to get them read in to those proper security clearances and then briefed on what the threats are on the national security side of the house, and also trained on how to handle sensitive sources and methods, including SEPA, the act that governs how you handle classified information. So at the end of 2012, for the first time, we cross-trained hundreds of lawyers across the field, and now every U.S. attorney's office is mandated to have at least one person who's a national security cyber specialist. And most offices at this point have units that are designed to focus on these threats. At the same time, for the first time, the FBI issued a communication to the field that said, "Thou shalt share," what had formerly only been on the intelligence side of the house. They had to open up that door and share it with those who are now specially trained in the offices. And our folks know, the lawyers and the prosecutors, that 95% of the time, there's not going to be a solution that involves a criminal prosecution when it comes to a national security threat. And here I'm defining that as an act by a nation state or its proxy or a terrorist group. But what are prosecutors good at? Well, first let me talk a little bit about what the threats are that we're seeing in this space and that we've seen over the last couple of years. Applying that new approach, what we saw, as I described to you, was this theft that's occurring day in and day out. And for a period of time, we had not used the criminal justice system to address that threat. Not sure that was ever a deliberate, intentional policy choice. Partly it's because no one was looking at it. Since we weren't sharing the intel and law enforcement, we weren't seeing whether such a case could be made. This new approach and dedication to doing deterrence and disruption led directly to a first-of-its-kind case that was somewhat controversial at the time, and I'm sure we're going to talk about more, which was the indictment of 5 members of the People's Liberation Army, Unit 61398, for their activity, and it was laid out in meticulous detail. These are only allegations, it's in a complaint, but that they were day in, day out targeting a range of American industry, from solar to nuclear to steel, that they were stealing from management side and the labor side from the unions who were trying to litigate against them for unfair practices. And what they were taking was not traditional national security information. They're not trying to figure out our geopolitical strategy. What they were taking, when you look at the complaint, is, for instance, they'd be doing a joint venture with an American company to use nuclear power plants, and they would steal the lead pipe specifications that they would otherwise be paying for to lease from that company. Or they were stealing the pricing information from a solar company here so that they could dump material inside the United States at exactly the price point below where they knew, because they stole it, their competitor was pricing the information. And what we saw, too, and laid out in the complaint, was that this was activity that spiked at around 9 o'clock in the morning. It then continued until around 12 o'clock, took a pause, from 12 to 1, resumed until 6 o'clock. So luckily, they, unlike you guys probably, their work day still is around 8-9 hours, because it would decrease over the night. But this was their day job. These were members of the People's Liberation Army in uniform, and their day job was to go in, target U.S. companies, and steal from them their competitive strategies and their intellectual property. Our companies can't compete against the full resources of a nation state. They can't compete against a military or intelligence. And it's fundamentally got to be the job of the United States government not to leave it to private companies on their own to try to protect themselves against these types of attacks. And what you saw in that case was an approach that involved, one, you had to actually be able to figure out who did it. This is the investigation and attribution work. And that requires sharing the intelligence across that divide. Once you figure out who did it, we can't be afraid to say publicly what we figured out. It can't remain a classified secret. Going back, I think it was only in 2011, or it was definitely 2012, there was a report, where as government officials, we were allowed to say what we had been seeing for years, which is that the Chinese government was going in, targeting U.S. companies and stealing information. Before that, we had to say vaguely that it was occurring, that foreign countries were doing it. So you got to figure out who did it, and you have to be able to say who did it. And third, there needs to be some type of consequence. And in this particular case, it came in the form of a criminal indictment. So we tried out that approach there. And then we had just done a restructuring at National Security Division, whereas for the first time I have a deputy who focuses full-time on protecting our national assets from economic espionage, including cyber-enabled economic espionage and export. Now, his first couple weeks on the job, he got a call, and it was because of the attack on Sony. The attack on Sony was a destructive attack. It inflicted significant damage against their machines, and including wiping information and keeping them from being able to use their communications. And it was done for a political purpose. It was done because of free speech. It was a North Korean government trying to prevent free speech here. And I can tell you, when we war-gamed out, prior to this, there had been much discussion of the likelihood of a national security related attack, that there'd be a nation-state attack. No one, however, was predicting that it would be over a movie about some bumbling pot smokers. How many of you have seen the movie? I view that as the responsibility of the North Koreans for so many of you to see this movie. I tell you, it's one of the few times that I've had to brief a movie in the Situation Room of the National Security Council. We have to give some explanation of what this was. Reviews differ on the movie, but the fact is they had the right to produce it. So we get the call. It's that a nuclear-armed rogue nation has attacked Sony over this movie. What are you going to do about it? One thing that Sony did right, and here's what's different when it comes to the cyber area than, say, terrorism. In terrorism, one of the key problems was how do you share information between law enforcement and intelligence to make sure we apply the full range of legally available tools. But with cyber, it becomes one step harder, because we also need to be able to share with private industry and back. Because the private industry is where our critical infrastructure resides. It's where the intellectual property resides that's being stolen, and it's going to be targeted because of our values, like free speech. What Sony did right, and was also required in order to bring the PLA case, is getting the cooperation of the company. Sony came in within hours, shared the necessary information, and allowed us to apply this new approach that's been tried out once before now, where we immediately work on investigation and attribution, and in around 27 days we're able to definitively determine that it was the North Koreans, and then to make the decision to be public about it and say that it was the North Koreans, which you saw the president do. And the third part of the approach there was to use an already existing executive order that had to do with North Korean behavior to add additional sanctions against North Korea. And also, you heard the president and other officials say there'll be some things you see and some things you don't see, but there will be consequences. In terms of the nature of the debate, it was very important, we thought, to respond in terms of not just because to send a message to North Korea, but to all of the other countries who are exploring using this new tool of power to show that there would be a response. And part of that, again, is showing them that it's not anonymous, because if it's anonymous, it's cost-free. This isn't an anonymous tool. This is one where we can and will figure out who did it, and when we do, there will be costs. It's particularly important because we're seeing the physically destructive acts now that were often hypothetical. There was an attack, according to a report put out by the German industry, on a German steel mill. I don't know how many of you are familiar with that, but this was a cyber-enabled attack, and it went in and disrupted the override systems on a steel mill that would keep the cooling system in place, so it overheated and exploded. So it was physical harm caused by a cyber-enabled attack. So there's the physical scenario, there's the theft scenario, there's a scenario like OPM, which we haven't characterized, that's been characterized publicly as one where they've stolen background security clearance files. You've also seen ones like Blue Cross Blue Shield, where you don't see an immediate economic benefit, but you can see intelligence reasons why people would want it. And what we're also seeing is that in 85% of these attacks, in terms of the defensive side of the house, according to one study by Department of Homeland Security, these are existing vulnerabilities that could be patched by the companies. Now, no company can put in a defensive system right now in an internet-enabled computer that would keep a dedicated nation state from keeping out of their systems, which is why it is a government issue. At the same time, we need to encourage people to improve their cyber hygiene so that we're not plagued by the lower-level attacks. If we continue to make it harder for people to do what they want to do in cyber-enabled space, that raises the costs and hopefully pushes people out of using this method to attack companies. We're also, as I said, the terrorists have declared their intent. Back in 2012, Al-Qaeda in particular said they want to do through cyber what they did to the aviation industry. So we don't need to guess at their intention. They've said it. And that was the head of Al-Qaeda at the time, Zawahiri. We've also seen and just recently charged the first of its kind case where we charged both Computer Fraud and Abuse Act, hacking, but also material support to a terrorist group. And this is a case, and these are allegations, and the defendant will have the right to defend against them in court. But focusing less on the defendant for a second, I just want to focus on what it looks like from the point of view of the company. Because in this case, according to the allegations, on the company side, the company in the U.S. sees what may look like traditional criminal activity and low level at that. Someone stealing personally identifiable information, about 100,000 identities. They do so through traditional computer hacking. Then when they try to boot the guy out of their system, they get an extortion threat that says, I'm going to embarrass your company if you don't pay me $500 through Bitcoin and pay me off. A lot of companies today are just paying them off without reporting it. In this case, the company worked with government, and what they wouldn't have known if they had just dealt with it on their own was that this individual was stealing the personally identifiable information from the company, according to the allegations, and then this was an individual who had been a Kosovo extremist who moved to Malaysia, and from Malaysia was attacking the U.S. company. Then on the back end, after he took the personally identifiable information from the U.S. company, he was providing it to a British citizen living in Raqqa, Syria, Junaid Hussain, who was with the Islamic State in the Levant. That individual was culling through the data and picking out government addresses, posting government or military addresses online through Twitter, through US-provided free technology, and calling for those individuals to be killed with their information online. And then that individual, Farizi, is now pending extradition from Malaysia. Junaid Hussain, according to CENTCOM, was killed in a strike in Syria. But that gives you a sense of some of the complexity that we're facing day in, day out in national security law, but also the way that looking across the law enforcement and intel divide, you can provide different legal tools to do what you can to disrupt them from what they want to do. And similarly, just saw for the first time, and this is an allegation as well, but a charge of solicitation for an individual who reposted one of these threats with specific information on killing servicemen, reposted it. This is someone who lives inside the United States with a call to kill those individuals, and was charged for solicitation here inside the United States. So To back up a sec, one thing that I think we got so used to that we haven't been good at explaining is what national security law is today. Because I think when you're in law school still, I'm curious, but a lot of it, the discussion is over international law, and those are important issues, or over the laws governing military conflict, the laws of armed conflict. But day in, day out for a period of time now, the day-to-day practice of national security law has been one of problem solving. It's been one of looking having a general strategy where you use the intel to define what the threat is, but then looking across code books both here and in other jurisdictions to figure out how we can maximize the leverage to disrupt the actors. Critical to doing that, and this will be true in cyber as well, is figuring out who did it, attribution. And there's no one better, submit to you, at doing that than the FBI working with prosecutors throughout the country, because what they're trained to do is focus on investigation and attribution that goes down to the particular. So for general intelligence purposes, it might be sufficient to say, we have a high confidence this is China. But if you're going to go public with that information or make a significant foreign policy decision, you're going to want the highest level of confidence. So they're good at getting down to the detail, which means, for like in the PLA case, figuring out by name and by face who is behind the board, not just generally who did it. But it also, this group is trained at finding out that information and using legal tools to do it in a way that can be used publicly, because that's their job. That doesn't mean that we're going to end up in this space using it in the criminal justice system, but it gives you that extra choice as a policymaker to be able to be public about it. And it's hard in this space, don't get me wrong, in attribution. But there are results. I think without the case against the People's Liberation Army, 5 members, and then post that and post Sony, we realized there's not an executive order on the books that covers general cyber-enabled activity like there is for weapons of mass destruction or like there is for terrorist groups. So on April 1st, the president signed a new executive order dealing with cyber. There was much discussion that when we used that executive order, it was going to include sanctioning Chinese-related actors. Right before President Obama met with President Xi sent over one of his top advisors, along with a large number of other individuals, over 30 folks, to come in and try to negotiate prior to the President Obama-President Xi summit. Then at that summit, you saw President Xi say for the first time that the theft of intellectual property to use not for general government purposes, but to use by your competitors, by other state-owned enterprises or companies, is theft. Now, we had said that for a while. There were some, perhaps some at Harvard Law School, who said that China would never accept that that was theft because they just look at the problem differently. But President Xi now, I think, has affirmatively said it himself, and you saw closely followed on that at the G20, that the G20 also adopted as a norm in this world going forward, that is unacceptable, that it's theft, that it's economic espionage. Now, again, prosecution may not always be the right choice, but public attribution without prosecution still can accomplish deterrence. It can have positive effects on victims. I can tell you, having sat down with many of them, they often wonder, they see downsides to cooperating with government or saying what's going on in their system. But because they weren't seeing any result on the other end, they weren't seeing the same type of upside they get when they work with us in, say, a traditional economic espionage case now. So knowing that there are cases where we'll go forward has made a difference. And there are consequences for the hackers. Hackers like anonymity. They are used to the idea that no one can catch who they are. But at the end of the day, they're not fingers at the keyboard. Those fingers are attached to somebody. And when they get exposed, they don't like it. They can't use the proceeds sometimes because of economic sanctions. They can't travel. They're embarrassed. And it can enable other government tools. I'll quickly tick through those, and then we switch over to the discussion. But you've seen some innovative tools in this space, and I encourage you guys to think of others as you go forward. But using already existing, patchwork of already existing statutes, you saw in the Game Over Zeus disruption, not just attempt to criminally prosecute the people responsible for a giant botnet that, among other things, used this code called CryptoLocker. So you'd be working on your computer, it would suddenly freeze, it would be encrypted, you'd get a message that says, if you ever want to see your data again, you need to pay us off. They disrupted by going after the criminal actors, but also by working in an unprecedented way from government to government, but also private sector to private sector to clean up that botnet, to find the command and control center and disable the botnet. I talked about the executive order and the use of a diplomatic response like Sony. And it may be in some of these cases that there are necessary military responses as well. But that will depend on our ability to figure out who did it. In terms of helping the private sector, I think we've gotten better at sharing information. The FBI has a program called InfraGard that has 30,000 members. The Department of Homeland Security has a cyber center that's dedicated just to receiving and sharing information to improve defenses. And what we're starting to get better at, but really needs to continue to improve, is how do we share the classified information? And so you've seen two initiatives. One is to try to declassify more of that threat information to get it back out to the private sector, but also to give classified threat sector briefings with either non-disclosure agreements or with with personnel at companies who have clearances to tell them what we're seeing in the national security side, even if it comes from sensitive sources and methods. So before I switch over, I'd say in conclusion, the cyber threat that we're facing, it's here, it's real, and it's growing. It's a threat that we must fight back on. When you think about how much we moved quickly as a society, we moved 98%, say, of what we value from analog space, according to one study, to digital space in 25, 30 years. That was a massive investment of money and intellectual capital to accomplish a very, very rapid transformation of our society. We did not, at the same time, invest in the security of that information. And we used a protocol that was fundamentally not designed to be secure. Our ability to move quickly to digital space has given the American economy great advantages throughout the world. But what has been a strategic advantage can turn into a disadvantage if we don't now quickly try to keep pace and improve on the security side of the house and take real the threats that are out there. So from our perspective, we feel we're a bit of a race against time to get better both at doing the investigation and deterrence side of the house, but also the defensive side of the house, while at the same time our adversaries, both nation states and terrorists, are also trying to do what they can to figure out how to disrupt that digital system. And we need your help. So for those of you who are thinking about this space, strongly encourage you to go into it. There's not a day that goes by that we're not facing an innovative legal problem. There's no cut and dry solutions in this space. And it requires all parts of you. So it requires your legal acumen, but also your judgment and thinking through not just what we can do, but what we should be doing in this space as we try to preserve the digital space as one that allows for communication, growth of economies, for free speech, but at the same time keep it safe. So thank you, and I look forward to talking more with Jack.
I'll ask a few questions, and then we'll open it up. So John, thanks. That was great. And I want to compliment you on something you didn't say, which is that every one of the steps that you described, including the sanctions, especially the public disclosure of the naming and shaming strategy, I know what kind of a push those seemingly simple and obvious steps take inside the government to get that stuff published. Actually, you could see, reading between the lines in the newspapers, that it took a huge push just for years, it seemed, just to be able to say the Chinese are behind this. And for outsiders, we can't understand that. So my first question is that just a sources and method issue? Why is it so hard? Why did it take so long just to be able to say, not because you knew the Chinese were doing it, you were leaking, not you, but the government was leaking to the press that the Chinese were behind this, but you never said it publicly until I think a couple of years ago. And what in general are the hurdles to more naming and shaming?
That's a good question. So I may not have the definitive answer, but I'll give some thoughts. One is, if you think about the apparatus we built up in the Cold War, and the genuine need to protect sensitive sources and methods. The balance might tip in some cases to keep protecting the sensitive source and method that allows you to see what your adversary is doing on the intelligence side of the house, the cat and mouse spy versus spy game. It didn't always mean, because in my division we go after spies and prosecute them, but it meant in a lot of cases the decision was, we know what they're doing, we know generally what they're collecting, we'll let it stay in place so we can monitor what they're collecting, and vice versa. And that created an enormous amount of inertia that this was an intelligence problem, and that's the way you handle intelligence problems. But the issue was, they said this wasn't a traditional intelligence problem because it was causing real harm day in, day out. It looks like traditional criminal activity from the point of view of the victims suffering the theft. It was putting people out of work and rendering it so they couldn't compete. So part of the discussion is, how do we, recognizing that, treat that part of the problem as theft? And then the second, I think, issue that will remain is the fear of retaliation, and what's the right tool in order to change behavior towards a world order that's premised on the idea that companies should compete, but compete fairly. And so there's always going to be concern, I think, when you do something new. What are the unanticipated consequences?
Is it fair to say, are you allowed to say that there's, because of the Korea case and the China case, is the government getting more comfortable with this? Is that fair to say?
That's my view.
Okay, all right. So there was a story by Alan Nakashima a day or two ago in the Washington Post about the indictment of the Chinese generals. And people like me said at the time that I doubt that's going to have much of an impact on China. If China's really gathering tens and hundreds of billions of dollars of economic benefit, it's not likely that bringing in an indictment that won't ever be pursued, and that you probably, frankly, don't want to pursue because of the classified information issues that you'd have to, I assume, deal with if you actually got your hands on them. So can you tell us the mechanism? And one hears things like, well, that this naming and shaming is really important to the Chinese, and in fact, despite the hundreds of billions of dollars of benefits, they're actually going to stop doing that now because we named 5 generals in an indictment. It seems implausible on its face. So what can you tell us about the mechanism that maybe is getting them to change their behavior? One assumes that there has to be a lot more going on.
First, just to be, in terms of the facts as alleged in the case, they're not generals. We didn't allege that.
Chinese officials.
Yeah. And they are the specific individuals. They're not named generally. They're named because of specific acts on specific times in specific places where they were stealing from real companies, as alleged, in violation of our economic espionage statutes, Computer Fraud and Abuse Act, and theft of trade secrets. And it is absolutely our intent was to be able to proceed in a criminal court. So just for the other, I look forward to the day with all the attendant rights and due process of American law that they face justice, and we're ready to proceed.
You think that's going to happen?
Court. Whether we're working to make it happen, but just in terms of whether we're worried about whether we hope it happens, fully prepared to proceed, or we wouldn't have brought the case. And it is hard to do those cases, but we wouldn't have brought it unless we're ready to go. In terms of the impact, I know there's a debate. I know some people feel strongly that it had a very profound effect. It did a couple of things, because one, it laid out, there may be some who doubted that we could figure out with this degree of specificity exactly who did it and what they did, so put that to rest. Secondly, there were some who figured if we did figure it out, we'd never do anything about it. We've been talking about it for a long time, but we hadn't done anything about it. So you could get comfortable with that calculus. 3, big complicated country. I won't name any other country's name, but there's some other country where disclosure of intelligence activities caused a lot of internal changes, discussion, and debate. And it may not be that everyone in the government over there knew exactly what everyone was doing or had thought about the consequences of what they were doing before it was publicly named and exposed. And that happens not just here, but as a general rule, spies don't like to get caught, and there are usually consequences when we catch a spy and bring a case. Also, as part of the thinking, though, I would imagine would be the executive order that's in place now that would allow for the sanctioning of actors, and that plus the criminal case, I think, showed a determination that at the end of the day, and I don't know which will be the triggering event, but we need to make a decision as American companies and citizens, and hopefully other countries around the world, that we will keep raising the costs of stealing in this manner until it changes. And this should be an area, unlike some, that is a cost-benefit analysis, because they're not stealing for an abstract reason, they're stealing to make money.
Right.
So if we can keep increasing the cost, at some point those benefiting from it are going to say, hey, it's cheaper to invest in research and development, it has fewer consequences than to try to compete by stealing.
So that answers a question I had about really the indictment, the information publicly revealed in the Sony hack and the like. Frankly, that's the U.S. government throwing out some facts, and there's no proof yet at all. And a lot of people are very skeptical about the representations. I have zero doubt that you have facts to back both of them up. But for the rest of the world, the Sony hack especially, there was a lot of controversy about whether it was Sony, and it wasn't really until private third-party entities confirmed it that the U.S. government was believed, in my opinion. But if, in fact, the story you're telling is that the Chinese become aware of what's going on in their own government, then you don't really need kind of publicly available proof if they can figure it out. So that actually makes a lot of sense. It answers that puzzle at least a bit. So my final question before I turn it over is, so everything you described, given the general scale of the problem, seems like not enough. I mean, given the way the government describes the cyber threat, both on the espionage and the attack side, given the growing proliferation of actors that have access both on the terrorist side and other countries' side, given what one reads about Iran and what one reads about Russia, I mean, do you think that you're getting good enough, fast enough, and do you have enough resources to deal with the growing problem? Or do you think, you talked about it as a growing problem, are we getting better faster than they're getting better?
I'll say this. I think compared to where we were, say, 10 years ago when I was hacking this, over the last several years in particular, not just in government, but there's been a sea change in the private sector at recognizing the scope of the threat in the so-called C-suite, at the CEO level, general counsel, board level. For a while, and I think part of this is because, this is as someone who's been doing hacking cases for a while, but a lot of people don't speak geek. And so you had the IT professional side of the house handling the threat, and no one understood what they were saying. And because they would talk, but then people would tune out, and it wasn't really going into like the risk mitigation strategy the way you would with a risk like money laundering, depending on where you're doing business, or the Foreign Corrupt Practices Act, which no major corporation these days doesn't have a risk mitigation plan. So it had to penetrate in a way that seemed real, and for probably a lot of reasons, but the Sony had probably more than any other was a wake-up call, the canary in the coal mine. I think partly it's the entertainment industry, so a lot of people who don't normally read about cyber were reading about it, and because it felt real, I think, to the CEOs, because personal email, even though that wasn't the most destructive part of the attack, was exposed. So we've moved incredibly quickly in a relatively short period of time, but no, I think we need to move faster and do more than we're currently doing. And we need to keep increasing the speed, given the scope of where we know the vulnerability is and the dedication of some of our adversaries. And it may be, there are different parts of that puzzle, one of which is bringing deterrence into the game and disruption into the game. It's kind of amazing that it really wasn't there at all until, or a major part of the conversation, until we did the PLA case. So that's a very short period. That was in 2014. We didn't have this approach until the end of 2012. So that's one part. The other part is we might innovate our way out of some of the problem, but that means recognizing that right now there's not an internet-connected computer or system that's safe from a dedicated adversary. So that means when you're thinking about it as a risk mitigation problem, you have to assume they can get in. So do you design your system in a way where we no longer put the crown jewels in the crown jewel folder, which was practice, but if you assume an adversary is in there, you might use different naming conventions. It also means focusing on resilience. Assume that there could be, depending on, you have to do the measure of the risk, but if you're in an industry that's likely to be subject to an attack, have you thought about resilience? What's your investment where you assume your main system's going down that could get you back up to the business that you're in, particularly if you're in the critical infrastructure business, as soon as possible to deliver the service that you need to supply. And then finally, in terms of the innovate out, is there another? I mean, we've got the best minds in the world. It's amazing. Now it seems like we have to do it in the way that we're currently doing it, in terms of our internet-connected system. But what's the next generation? Is there another technological solution? Does it make sense for the finance industry to do financial transactions using a medium that was designed for communication and information sharing? Or is there some other technical solution that wouldn't be as vulnerable to cyber-enabled attack that's waiting for the next great entrepreneur to figure out?
Great. Okay, let's open it up. We have some time for questions. Who wants to ask questions? In the back, yes, sir.
Hi, sir.
Let's try to keep them brief because we've only got 7 or 8 minutes left.
You mentioned kind of a cocktail of strategies that the government may use to potentially deter this sort of behavior by foreign governments. A lot of things you mentioned, though, were kind of fundamentally based on neutralization of the threat. What role do you think exploitation has in I guess, changing the behavior of the foreign adversaries that do this sort of work?
What do you mean by exploitation?
So you gave the example of watching the data being exfiltrated on the screen, right? So someone might look at that problem 2 ways. We need to stop it right away. We need to neutralize that threat. Somebody else may say, well, if they're taking this data, what can we do to exploit the behavior that they're doing? So there's risks and rewards associated with all those approaches. But I guess my question is just, what's the right balance in your mind of how we address those issues?
That's a great question. So to my mind, it's got to be, again, we have to, it's got to be iterative. We got to be responsive to, we have to keep trying new approaches until we change the behavior. And so it shouldn't be an either or. So one response to watching it get exfiltrated might be, let's figure out who did it and prosecute them, sanction, get a foreign government to prosecute them, use diplomatic methods to call them out. Another might be, don't do anything publicly, but instead work to make sure the information that they're exfiltrating doesn't work as intended. It's either gibberish because they're unable to ultimately open it, or it looks like it's going to be a valid design for a system. But in fact, when they invest years going down this path of thinking they're exploiting what they've stolen, it doesn't work. Now, those present legal issues. And I can tell you, companies exploring those approaches are worried sometimes about the liability. They wouldn't want to make, for instance, have a design flaw that worked almost as intended but caused safety issues. So those are issues now where we've been encouraging people come in. If you're want to try an innovative approach, work with us. We might be able to give you the stamp of approval that keeps you from being liable. And these are the same types of approaches we've used for years in traditional espionage, where you provide information that's actually not of value. And once that confusion, that lack of confidence in the integrity of the data that you're stealing, in and of itself, is a way to greatly raise the cost of getting it in that means.
Yeah.
You spoke a fair amount about the extent to which your office cooperates or even takes lessons learned from the FBI. I wonder if you could speak a bit about the extent to which your office cooperates, collaborates, leverages the growing capacity of the U.S. military in the cyber realm, Cyber Command, as well as, I guess, there's some new national cybersecurity center that's been created within the intelligence community.
Day in, day out, that's why our division was created. So I sit in the terrorism space. To give you an example, we sit around the table in the security, in the situation room at the National Security Council, and we'll take a terrorist group or threat and go around the table and see what strategies we should have and who can bring what authorities to bear. We're starting to apply that same pace and approach towards cyber threats, and that includes working with Cyber Command, NSA, CIA, the full suite of the intelligence community. And I think the program you're referring to for the intel community would be trying to create a group like the National Counterterrorism Center that looks to combine all the sources of intelligence and give a definitive view of the government as to the attribution of the threat. And so that's an important thing to have at your disposal.
Yes, sir. And then we'll go to you. Sorry.
You mentioned some of the I guess, movement with the Chinese over the last few months where they've begun to accept or potentially even endorse the U.S. position on economic theft using cyber means. Without disclosing the ongoing investigations, have you seen an actual drop from the Chinese over the last 2 months in their attempts to steal economic information from companies?
I'd say, as the president said, we need to be clear-eyed and actions speak louder than words, and see what the actions are. It's too soon to tell. You've seen some, because this is an area where private companies do their own research, you've seen some public debate play out. I think there are some, and that was the article Jack was referring to, who think there has been a definite decrease. There are some who think activity is still occurring, but generally the verdict is too soon to tell. But bottom line, if there are, it shouldn't be controversial now. If we catch someone stealing from a company, that if we work to prosecute them or sanction them, because everyone now agrees that it's theft. We'll see. Yes.
So one interesting news development, I believe the other day, was that the official Chinese newspaper admitted that Chinese hackers had been responsible for OPM and claimed it was criminal activities. And it does seem that a certain amount of the apparent crackdown on PLA commercial cyber espionage has also been sort of carried out by characterizing this as purely criminal, as PLA officers moonlighting rather than officially sanctioned state policy. And for instance, the arrest of a number of PLA hackers a couple weeks ago, I believe, was also sort of framed in terms of they've been moonlighting. And potentially the party could make the argument that within the context of its crackdown on corruption and efforts to reform the PLA, it's managing to eliminate these activities, which previously had been the result of sort of the lack of awareness, as you mentioned. I was curious whether you see this as sort of an attempt to obfuscate the situation and sort of deny official responsibility, and whether there are any indications of a more sustained policy change and shift, and sort of admitting that there had been state responsibility rather than characterizing all of this as criminal.
So without commenting on that specific news article, the bottom line is, does the behavior change? Are our companies, do we see a change in the companies getting victimized by the theft through cyber-enabled means of intellectual property? And if the behavior changes, at least from where I sit on the more of the enforcement side of the house, that's what we want to see, regardless of what the explanation is for why it changed. And that should be ultimately measurable, as long as we have cooperation of the victims. And we also just left D.C. We're meeting there, the Attorney General, Secretary of Homeland Security. We're meeting with the head of the MPS, the Public Security Services in China, in a dialogue that started because of these agreements. And that's new, to have that type of direct connectivity and discussion about cybercrime across the gamut. And there's certainly cybercrime committed by people in both countries where we need each other's help, because it's such an international crime. So that's a positive development. We'll see how it plays out.
Can you ask your question in 10 seconds?
Yeah, sure. I just wanted
Very brief.
In terms of like surveillance and policing the internet and stuff that the NSA has been doing and all of that, I'm struggling to see how any of that bears much relation to the kind of work that your team's doing. Is it of any value to you, or is it entirely separate?
That's a broad sense. I don't know if I can answer that one quickly, but
It's fair to say that you work with the NSA. I think you can say that, right?
oh yes,
Yeah, okay.
I think that's fair to say, and I think it's one of these areas where it's easy to demagogue on each side of the issue, but ultimately, if you want to stop bad guys from doing bad things, be it nation states, terrorists, or crooks, which is what we're doing, you have to be able to figure out what they're doing. One of the ways to do that would be through traditional criminal process. That's great inside the United States or inside a country's borders. But you also got to figure out what they're doing outside. And sometimes you're working with a friendly country, and sometimes you're not. So the ability of whether it's NSA or other intel services to figure out who's doing what is going to be critical, I think, to ultimately addressing it.
Great. Thank you so much, Tom. Well done.
Thank you.
Thank you very much.